There are strong legal protections in Ireland for workplace assaults. This is a guide to assist an employee understand their rights. Employers can be held vicariously liable for acts or omissions in respect of the wrongdoings conducted by an employee against another employee in the workplace. Employers' duties and responsibilities. The 2005 Safety, Health and Welfare at Work Act is the main legislation on workplace safety and health. It applies to all employers, employees and sole proprietors. Under Section 8 of the Act, employers are responsible for ensuring employees' safety, health and welfare at work to the reasonably practicable limit. If any employee should suffer physical injury or mental injury because of the negligence of the employer, an employee is entitled to seek a legal remedy. Health and social care workers. Certain workers, such as those in the healthcare sector and social care sector, are more at risk of injury at work due to assault. Scheme for healthcare workers. If assaulted at work, there is a HSE scheme for nurses who sustained injuries due to assaults in the workplace. Guidelines for the operation of the scheme have been published, which detail the eligibility requirements, rules and sick pay entitlements, etc. There is also a personal injuries insurance-based scheme for nurses explained in the HSE HR Circular 04A/2008 and 2017. Redress for unfair dismissal. When an employee is dismissed unfairly by the employer, he or she has the right to seek redress and bring a case to the Workplace Relations Commission. Workplace assault legal remedy. If you have been injured as a result of the actions of someone else, you will have suffered what is termed a tort, which is a civil wrong, and as an injured party, you will have a right to initiate a legal action. Employee responsibilities. Section 13 of the Safety, Health and Welfare at Work, Act 2005, outlines an employee's responsibility in terms of workplace safety, and an employee has to take reasonable care for their own safety. Report the assault to the employer. The assault should be reported to the employer. This can be human resources, a manager, etc. Personal Injuries Board. If a person has sustained such an injury which has negatively affected one's life as a result of negligence, the Personal Injuries Board is tasked with dealing with personal injury claims. If all the parties agree to the Injuries Board making an assessment of the application, then the Injuries Board will proceed to make an assessment of the claim. This is a monetary sum. The Injuries Board make their decision based on what's called the judicial guidelines, the medical reports on file, and the special damages, i.e. out-of-pocket expenses of the applicant. Once the Injuries Board make their assessment, i.e. their decision, they write to the applicant and the party responsible for the accident and await a response from both parties to establish if they agree to the board's assessment sum or not. If the injured person and the other person respondent both accept the award, then the Injuries Board will make an order to pay. If one party does not accept the award in question for whatever reason, the matter has not been agreed to, and the Injuries Board then won't grant an order to pay. Criminal Injuries Compensation Tribunal. Victims of crime can make an application to the Criminal Injuries Compensation Tribunal. The tribunal can grant awards for special damages, which are out-of-pocket expenses, but not general damages, which are for pain and suffering. Non-Fatal Offences, Act 1997. Section 2 of this Act details the offence of assault. Assault causing harm and then serious harm are dealt with under separate provisions. If you have any questions, our contact details are 01 546 1121 or 052 612 1999, or our email address is info@clearysolicitors.com, personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement.